Hello, everyone. Daniel Forouzan, host of the Schmoozin with Forouzan podcast. Very excited, guys. We have a big treat today. Paul Kiesel, founder of the Kiesel Law firm. And we're going to be talking about some big picture stuff. Paul is a big picture guy, as far as I can tell. He deals with very large class action, mass torts, big picture stuff like that. For the five of you who don't know who he is, let me just give you a little history of Mr. Kiesel here. Long-standing impressive history as a trial attorney in Southern California. But check this out. President of LACMA, appointee to the California Judicial Council Civil and Small Claims Advisory Committee. He's a lifetime board member of CAOC and CALA. If you know who Paul is, you're well aware of his accolades. If you don't, you've probably been living under a rock. But the good news is you'll actually get to meet him and learn about him here today. Paul, thank you so much for being with us.
Daniel, thanks so much for having me participate in this great process. I'm really glad to talk to you and share some thoughts with folks that are viewing us.
Absolutely. I know a lot of people are actually excited. I told them, hey, I got Kiesel on the podcast. They're like, whoa, you got Paul. And yeah, I did. And, you know, one thing I want to point out, Steve Archer, partner at your firm, long-standing mentor of mine, been a very generous person. And also Jeffrey from your firm was one of the previous episodes in the podcast as well.
Well, I'm in good company then. And of course, I know Steve Archer is one of the best mentors you can have. And quite frankly, he's mentored me. There are certainly lots of issues. To be a trial lawyer is to have questions, always questions. They come up every day. To have someone you can trust and you can turn to who has resources and availability for you is invaluable. I think one of the things I've always tried to do personally, make myself available to the trial bar. I love getting questions. I'm never feel that I'm being interrupted, and I'm just paying forward everything that was done for me throughout the course of my career. I can't tell you, Daniel, the number of times over the course of my career that I've had to pick up payphones, that's where you said the coins in a phone to make a call from the hallway of the courthouse to call lawyers far more experienced than I am to ask for help. That's the hallmark of what we do. Is we are a very collegial group of people together.
Now, let me ask you, do you think that's the plaintiff's bar, the defense bar, either or?
No, it's definitely the plaintiff's bar. I think that we are idealized by the defense bar, that we work so cooperatively with each other, that we have the listservs that we do. It's fascinating, right? Because theoretically, we're in a competitive environment. And yet, quite frankly, I always say there's so much out there. There's so much great work to be done that I'm always happy to share my thoughts without regard to, hey, that should have been my case. I'm happy it's your case. I'm happy to help you in any way I can. And we go from there.
Yeah, that was one of the interesting things I noted when I first started going to CALA events, and I saw how much fostering there was of younger, inexperienced attorneys such as myself at the time. And of course, that's something I have also learned to pay forward. I guess at the time I was thinking, geez, aren't all these people business competition with one another? Why are they helping each other out? But then when I realized is, like you said, there's more than enough to go around. The real competition would probably be the defense bar.
Correct. I think the defense lawyers are very wary of each other. There's a very competitive environment that happens there. And I think by and large, we're a really collegial group of lawyers, which is really quite enjoyable.
Yeah, I can't tell you how much Stephen or CALA and all these organizations, CAOC, have been an integral part of me growing up as an attorney. And believe it or not, I usually like to skip the, where are you from? What's your background? Kind of the basic ABC questions. But I have a particular goal on this podcast because I'm so fortunate to have you on. I want to get the big picture, how Paul Kiesel got to be Paul Kiesel, how you got jewel litigations, the Porter Ranch stuff, big picture stuff. So I do actually kind of want to jump into your background a little bit. Can you just briefly tell us where you came from, how you got into the law, what kind of law you started with?
Sure. I mean, I'm probably unique in that way, Daniel, just because when I was about 6 years old, if you said to me, what are you going to be when you grow up? I would have said a plaintiff personal injury trial lawyer.
Wow.
I mean, that was just, when I realized I couldn't be a doctor, I didn't have the dexterity or quite frankly, the intellect to be a doctor. And I wanted to help people. I knew that personal injury was just the perfect world for me to have mixed medicine and my ability to be articulate, I thought. And so since I was really young, this is always what I wanted to do. So in some ways, I'm really living the dream remarkably that I set out for myself as a little boy. But the path was not easy. So I was not, I was a creative person. I was an entrepreneur. I had 2 full-time businesses I ran in college, but I was not a straight A student. I mean, quite frankly, school was something I needed to get through in order to get to law school, because I always wanted to just get to law school. If I could have gone from high school to law school, I would have. But in 1982, which is the year I graduated from college, and I was applying to law schools. I applied to Columbia, I applied to Yale, I applied to Rutgers, a lot of schools. And it was May of 1982, and I'd been waitlisted at a couple, but accepted at none. It was a very competitive year for schools. And I was shocked because I thought, well, they'd look at my resume and they'd see my CV and I'd easily get into law school. And all of a sudden I found myself in spring of 82, not admitted to a law school yet. And a dear friend of mine who I went to college with at Connecticut College called me to say, hey, there's a school in California, ABA approved school, Whittier Law School, that's got a rolling admissions program, and maybe they've got some spots. So I picked up the phone and I called the law school and I asked for the dean's office, and the person picked up the telephone and I said, hey, can I have the dean's secretary? And the person said, this is the dean. I said, can I have the secretary, please? Because it just didn't even register to me that the dean of the law school would be the person who picked up the phone.
Yeah.
And he was like, this is the dean. I said, oh, well, great. I tell you what, I'm interested in applying to school. He said, okay, what's your GPA? What's your LSAT? I told him, he goes, okay, you're in. And there was silence. And I said, I'm sorry. He said, is that too honest an answer for you? I said, no, I'm so stunned. He said, look, if what you're telling me is true, if that's your GPA, I went to Connecticut College, if that's your LSAT, you will fit the profile and you'll be admitted. It'll have to go through the committee. We'll get back to you, but can you come out in the next week or two to do an interview? So I'd never been west of Pennsylvania. And I got on the plane with my dad and flew out to California. I'd never been here, obviously, before. And in a matter of a couple, 3 weeks, I had rented a home on Curzon above Melrose, between Melrose and Santa Monica, and found myself in the first year of law school at Whittier. And so I know this is a long answer to your question, but it's important to get the context. So I'd said always that I wanted to be an attorney. This is where I wanted to be. But my whole life, if I looked at every single teacher evaluation since I was in kindergarten, they would have said, Paul is not living up to his expectations. And I thought, you know what, now I really have to see if this is what I want to do, if this is really where I want to be. So I shut off everything. I put the business on the wayside, I shut them down. I focused exclusively on law school. And there were about 180 kids in my class. And at the end of the first semester, I was near number 1 in my class.
Wow.
And it was anonymous grading, which scared the hell out of me, because the whole time I went through my education, the only reason why I got decent grades was because they kind of knew me and took pity on me and gave me good grades. So anonymous grading scared the hell out of me, because now it's on me. And so I realized, hey, I think I'm now living up to my expectations. And so I did really nothing but focus on law school throughout the course of my education, and then passed the bar first time out and started clerking in my 3rd year at a very small personal injury practice known as Hoffman, Slater, and Slater. And Hoffman did the criminal work, and Van Slater did the personal injury, and Lindsay, his wife, did adoptions and guardianships. And my office was a block west of where I am today. In fact, I've only been within 3 blocks since 1984. I've only practiced within 3 blocks. I've never moved outside of this 3-block range. So It was my 3rd year, and I was clerking at the firm, and I really loved it. And I had the law school thing down, and Van was on the board of governors of the Los Angeles Trial Lawyers Association, known as LATLA. at that time. So before CALA existed, the Los Angeles Trial Lawyers was the organization, and Van was on the board of governors. And that was the entree to my practice where I am today. What CALA is today is what LATLA was then. And I devoted a ton of personal time to raising money and participating organizationally in meeting hundreds and hundreds of people in my early practice. And that's really how I was able to build the practice I did, by creating the relationships in those first few years, ending in 1988, when at that time there was an initiative to cap attorney's fees, to bring no fault insurance in the state of California. And it would have, I worked my whole life to build this career. It was, with one vote, could have wiped it out. And so Brown Green, who, God bless him, is still practicing law, Brown and I in 1988, together and with a bunch of other lawyers, raised, it was either $6 or $8 million. It was more money than had ever been raised before on an initiative like this. And I met hundreds of lawyers in the process and raised millions of dollars around, from Los Angeles to San Francisco. And I met all these lawyers who had never given money before. This was the first time we as a bar were really facing great jeopardy. And so lawyers who were prominent personal injury lawyers, marketing lawyers, early on advertising lawyers, thought, hey, if I'm giving Kiesel $10,000 and I don't give money to anybody, what might Kiesel do with this case? And so they started referring cases to me. So January 1, 1989, it became Slater, and Kiesel, and I've never looked back.
Relationships. You built that practice from relationships.
100%.
A couple of things for the audience to take note of, and all my podcasts have a sort of a self-help arc to them. I like self-help. I do a lot of self-help. First and foremost, people say lawyers are terrible to interact with. I am so engaged. Go talk to a trial lawyer. Trial lawyers know how to talk. And Paul, you're clearly no exception. It's very engaging speaking with you. I'm enjoying this greatly. And the second thing that I would want to point out to the audience, and everyone knows, network, your reputation, your relationships are often your livelihood. And, something else you pointed out, Paul, you said, I found this interesting. You said, I wasn't reaching my potential in my academics. How is it? You had 2 full-time jobs while you were in college? I think that's reaching quite a bit of potential. I think what it says, and I've heard other very established, well-to-do trial attorneys say the same thing. We work a lot. There's a work ethic there. And, what I'm curious about, I know Kiesel Law is a personal injury law firm, but that's, I think, primarily because of my relationship with Stephen Archer. But what I'm also aware of is you're in all these big mass tort class actions. Did you transition? Was there a threshold, or is it, hey, Daniel, it's all the same? How did that happen between doing, God forbid, a car that rolls over, to getting all the way to Porter Ranch?
Well, it happened actually in 1994. I never filed a class action before. I didn't know what a class action was, but I had a fairly decent referral base among lawyers around the city of LA. And a lawyer from Century City called me to say, I've got this case I just filed, and it's against a hair company. And they have a product that is supposed to straighten African-American women's hair. It's an all-natural, chemical-free hair straightener. And it takes kinky afro-like hair and it makes it long and flowy and delicious. And would you be interested in taking the case? I said, sure. So he sent over the case to me, and there were 12 plaintiffs listed in the complaint. And I thought, if these 12 women have had this problem, I bet you there's other people across the state and maybe the country who've had a similar problem. I think this is a class action. So I opened up the book on how to file a class action, Newberg on class actions, and we basically followed the script. And then I mean, because I'm thinking like a personal injury lawyer, not as a class action lawyer. I've got these amazing women who had their hair fall out because it turns out, Daniel, that this all natural chemical free hair straightener, it was called World Rio, was really like battery acid. You put it in your hair, it became straight and not kinky. And then 6 hours later, your hair fell out.
Aye.
And the company alleged that it was the way the women were applying it to their hair that was causing the problem. This is coming back to me. But Bobby Timberlake, my lead plaintiff, she was the infomercial model. The company put it in her hair and her hair fell out. So I thought, hey, we should do it. We should do a press conference.
Okay.
So I called up Whittier Law School and I said, hey, can I use your conference center to do a press conference? Because I got a really interesting class action case I'm filing. Now, to be clear, if you have a class action, don't ever hold a press conference. You never want a press conference when you're filing a class action. Tell you why in just a second. So I had just gotten some media training from the Los Angeles Trial Lawyers Association on how to make a compelling presentation on a claim. So I put together a big bulletin board, a big billboard, and I had pictures of my client before, pictures of my client after. I had baggies with her hair in the baggies. So there were like 8 television cameras that came to the press conference, and Bobby was there with me, and we announced the filing of this class action lawsuit, filed it in LA Central Court. And I prepared everyone at my firm that we'd maybe get some phone calls from people interested in getting to retain us for individual cases, because I wasn't thinking about a class action. I was thinking about getting individual clients because I'm a PI lawyer. I'm not a class action lawyer. Well, 2 hours after the press conference, around the United States on national news, this press conference started to air because there were tens of thousands of people who'd had this happen to them. And not only that, Daniel, they were using my 800 number. So around 3 p.m, every single phone line in my firm, and I had probably 12 lines, were just ringing. They were just ringing. And initially I was having my secretary and my staff take down all the information, send out retainer agreements. And then I realized by like 6 o'clock, this is overwhelming. And then I got a call from someone who had an 800 number that was just one number off of mine, because I didn't realize they were using my 800 number to call me. I didn't realize the media had published my 800 number. So it turned out in those days, there was like a number you could dial to shut your 800 number down if this had happened. I had a bill of several $1,000s for just the afternoon that these calls were coming into me. Long story short, and this is, I got a call from a lawyer in Philadelphia who'd filed one of these cases saying, hey, buddy, what are you doing? Why did you hold the press conference? Why did you file it in state court and not federal court? What are you thinking? And that person has since become a very, very dear friend of mine. And even though I was 34 years old, even though I'd never held the class action before, I was so in the lead of this national claim that I wound up becoming lead counsel in an MDL case, multi-district litigation case. In my very first class action, I was appointed lead by the judge in Cleveland, Ohio, where the cases got sent to, not because the judge would have appointed a 34-year-old kid who'd never had any class action experience, but because I knew the law firms that had brought these cases around the country, and I developed relationships with them and worked with them to coordinate what we were all doing together. And so when we all flew to Cleveland, Ohio, they unanimously asked for me to serve as lead counsel in my very first class action case. And that was the beginning for me of both my mass action and my class action experience. Wow, that was a story.
That is a hell of a story. The 34 to be, lead counsel on a multi-district litigation. That's a really, really big deal. And there's an undertone here. There's an undercurrent, I should say. You pointed out relationships, which is absolutely true. What I think your humility is putting to the side is reputation. Obviously, you had these relationships in part based on your reputation. A bunch of law firms wouldn't have asked you to be lead counsel if your reputation. So obviously, your reputation preceded you. And I think people listening at home, there's just gems that if someone wants to listen to what you're saying and read between the lines, you're setting up a blueprint for a successful law practice. And I sincerely appreciate you doing that. Let's switch over a little bit to nuts and bolts just a bit. Class action versus mass tort. For the people listening, most people listening are lawyers, so they're going to know the difference. But give us just a general understanding, difference between a class action and a mass tort case.
Sure. Well, and in fact, it was really the breast implant litigation that was the last kind of class action that was also a mass tort. Because basically personal injury cases cannot be class actions. Why? Because the nature of a class action is that claims are uniform, the damages are fairly routine across the group of plaintiffs, and there's not a lot of individuality that matters in a class action. Personal injury is the inverse of a class claim, that individuals have their own personal injury claims. Each claim has got to be individually evaluated, individually determined for damages, and individually tried. So that in the World Rio hair case was a class action, but it was one of the very unique class cases where it could also be a mass tort, because doesn't matter. It was a limited funds, mandatory, non-opt-out class action. It doesn't happen very often. So a mass tort is typically a medical device or a product failure that causes individual injuries, whether it's the Roundup litigation or the talcum powder litigation or the Wright and DePuy hip litigation. They're individual claims that are handled on an individual basis, but they're collectively managed by a trial court. But each claim has got to be individually investigated, individually discovered, and ultimately individually tried. So you'll hear bellwether trials. And I'll ask you a question. Do you know where the term bellwether comes from?
No, I don't.
Neither did I, actually, until probably the Porter Ranch litigation, which seems like amazing that you went this far in your career not to really think about what the word bellwether trial means, because we hear that expression all the time, a bellwether trial. Well, here's the deal. A male sheep is known as a wether. That's what a male sheep is. And the male sheep has a bell around his neck, and the other sheep follow the male sheep that has the bell around his neck. So the male who's leading all the other sheep is the bellwether. They all follow behind the sheep with the bell.
And so how does it, I've never done mass torts. I've done class action. I've never done mass tort. Is the bellwether trial, is it representative of the other members of the mass tort? And you're also filing these all individually?
Great question. So the answer is this, and it's happening right this very moment that we're talking, because I actually started this session with you by getting a call from Stephanie Taft, one of my associates, because we are right now filing actions involving the Carson Dominguez channel odor situation. Your viewers probably are aware that in Carson, California, there is hydrogen sulfide being released from the Dominguez flood channel. And there have been thousands and thousands of people who've been injured. They've got respiratory problems, they've got headaches, they have nausea because the smell is overpowering. Those are injury claims as a result of their exposure to the chemical. And each case has got to be individually filed and individually discovered, and ultimately will be individually tried should it get down to that, to show what the damages are for each individual plaintiff. So the Dominguez Carson Dominguez Channel case is probably the newest mass action right now here in Southern California.
And is it that, for the purposes of settlement, do you take a couple of the plaintiffs and evaluate their damages, or how does that work?
Great question. So here's how that goes. And Porter Ranch is a good example. So for those of you that are not familiar with, Porter Ranch is the residential community north of downtown Los Angeles. And there is a very large, one of the largest gas storage facilities in the nation that sits out there, Aliso Canyon. And there was a well that had a catastrophic failure, a blowout. And so a huge plume of natural gas was expelled into the atmosphere. And natural gas is the single biggest greenhouse gas we have on Earth. Mm. And so you had 35,000 people who were affected by the fumes, and 8,000 homes were relocated. Residents, 8,000 residents had to leave their homes for 4 months and get relocated while they tried to shut the well down, because it was not immediately shut down. It took them 4 months. It started in October, and they didn't shut it down until the end of February of 2016. So the case moves to trial, and now you've got 35,000 plaintiffs. Who are you going to try? Who are your bellwethers? How do you do that? So the court randomly selects a group of, let's say, 50 cases. And then you look at those 50 cases to see which of them are most emblematic of what the others have similarly suffered. So you try to get rid of the outliers and then narrow down to the 10 or 20 people who are truly exemplary of what happened to the rest of the community. That's what you do with a bellwether case.
And who makes that decision of the 20? Is it the plaintiff's counsel? Do both plaintiff and defense?
The answer is it depends on the judge. In the Porter Ranch case, the court went through a random selection of the cases and then gave the plaintiffs a chance to strike some and gave the defendants a chance to strike some. And so each side gets their own strikes to kind of narrow down what you hope to be the center core of plaintiffs that are truly representative of what the others have suffered.
So it's not quite like a class action where we select the class reps beforehand. We comb through them and bring the best forward, at least the ones that we think are the best for the case. This is something where everyone just gets signed up, and then through the judicial process, I don't want to call them class representatives, but the bellwethers, they get selected through the litigation itself.
Correct. Judge Lichman, who's now retired and he was at JAMS now Judge Lichman's at Signature. Judge Lichman used to say, look, plaintiffs, I want you to pick the bellwether cases. I want you to put forward your cases for me to try, which was an interesting approach because his attitude was, if you pick your best 6 cases and you lose those cases and they're your picks, you got to worry about your inventory. And you would tell it to the defense, look, let the plaintiffs put up their best cases. And if you knock them down, then you've really done what you need to do on the litigation. But that can be a risky approach on both sides. But that's how Judge Lichman used to do it. Pick your best cases, let the plaintiffs decide what they want to put up.
How did the defense feel about that?
Oh, they hated it. It was terrible.
Yeah, I could see that happening. Let me ask you, class action, we'll hop in mass tort in just a second. I wanted to break those two down for you. And, one thing I just want to point out, I do personal injury, catastrophic injury, wrongful death, employment. There is, to me, the whole world of mass tort is a separate animal, but I'm seeing the good you guys are doing, the Porter Ranch case or whatever it might be. And, people say, oh, trial attorneys, they're increasing the cost of business, blah, blah, blah. But for Paul Kiesel, but for the trial attorneys who are out there, the people living in Porter Ranch, the people living next to all the stuff that we've been discussing, what power would they have? So I also have another arch to my podcast, which is I am an advocate by work, but also I sincerely appreciate what we do is very precious work. I'm not saying every lawsuit that's filed is a good lawsuit. We all know about those. But, God bless, but for you doing what you were doing, what would these people at Porter Ranch be able to do without you?
And I like to say this, the best way to prevent the filing of frivolous lawsuits is to have a contingency fee model. Because why would I want to take on an action that I didn't believe there was going to be a resolution to? I'm not talking about, $1,000 and $2,000 claims. I'm thinking that the contingency fee process ensures a degree of evaluation well before they're ever filed.
Maybe we should talk off the air. The West Side Bar Association, which is the nonprofit that I founded, we have taken somewhat of a stance in regards to some of these proposals that are coming to the state bar. I'm sure you're familiar, whether it's non-lawyer ownership, paraprofessionals, or there's another one that's not a proposal in front of the bar yet, but I'm sure they're trying to cap contingency fees to 20%. Big business is back at it again. It sounded like you told me you already dealt with this in the 80s. And here we are again. Before I hop into mass torts and class action, do you have any feelings in terms of where the legislature is headed, where the state bar is headed?
It's hard to really know where the state bar, where the compass is with regard to the state bar. So I don't want to speculate on what they may or may not do. I think that since they have to be responsive to the legislature. One of our challenges as a legal community in the past, perhaps not so much so, hopefully in the future, is that term limits, as they came into being in the 90s, really took the best and the brightest who looked to politics as a career, and hopefully for all the right reasons. And there were a lot of lawyers that were members of our legislature, both the Senate and the Assembly, that 10 years ago, when I started fighting for court funding in 2008, and I helped form the Open Courts Coalition, the OCC, and the whole purpose of that was to get the legislature and the governor to fund back our court system. There were very, very few lawyers in the body that really understood what it was we did as the legal community. And I think those numbers have started to tick up. There's more lawyers coming back into the legislative process, but it was a little scary from an understanding perspective, not from we need citizen legislators, which is great, but they didn't understand the importance of the legal system. And this is a co-equal branch of government. And if you don't understand the importance of our legal system, then, and you don't fund the legal system, then we have a fundamental problem with our democracy.
Yeah. The judiciary is an equalizer. It's a balancer. It's keeps things in check. To what you said earlier about contingency fees, they say, oh, it's the plaintiff's attorneys increasing the cost of business. We don't litigate unless we have to. We don't get paid by the hour to file frivolous demurs and things of that nature,
100% agree with that.
Yeah. Okay. So let's talk about mass tort and class action. Big picture stuff. What do you look for in class actions? What do you look for in mass torts?
So in a class action, obviously looking for a harm, which is uniform. It's a representation, or it's a product that they sold and they didn't sell it as advertised. It misrepresented the product. I'm looking for some level of homogeneity, just some overarching, trying to find the right words for this, but I'm looking for something that, if you look at the elements of a class action, the claim is representative of what others have experienced. There's a numerosity involved. There's lots of people that have experienced similar harm. The damages they can be variable, but they can be provable on a class-wide basis. That's the kind of thing I'm looking for with regard to filing a class case. And of course, then I want to focus on who is the class rep going to be, because the class representative is going to be the tip of the spear for everybody else. And so you have to do your due diligence on knowing who your class rep is going to be. Make sure your class rep does not have any conflicts themselves to proceed with the case. Make sure there's no skeletons in your class rep's closet. And you really have to do your due diligence to make sure before you file that your claim is well represented by the client you've retained.
Okay. And then in terms of mass torts, do you go about it differently?
Oh, sure. I mean, mass torts, it really just depends on the nature of the claim. If you've got, I mean, you kind of name the mass tort for me to figure out what, it's such a broad topic area. I mean, if we look at Carson,
okay,
as a mass tort, so obviously it's an injury claim. So you need to make sure that you have an understanding of the injuries that people are going to suffer as a result of whatever the claims are. You want to make sure that there's medical resources available for the plaintiffs to actually be seen by doctors and be evaluated, so you can prove both your economic and your medical damages. And then on the other side of that is who's the defendant. You know, there's a lot of unfortunate mass torts where there's simply not a defendant that's got the sufficient resources to cover the losses that your clients have suffered. So you need to look at who is the actor that caused the mass action to occur in the first place and what's their financial viability, not just from the legal perspective, but from your client's recovery perspective. That's a factor. So those are all the different components that you're going to be looking at. Then where are you going to be filing? Is it going to be state court? Is it going to be federal court? Understanding the Class Action Fairness Act, CAFA, and how that plays into the action that you're filing. Is the defendant a California company, or is it a foreign corporation, in which case you're going to get removed to federal court almost instantly if you file it in state court? I mean, the Juul litigation, which of course is the e-cigarette litigation, is a good example of that.
Why don't we hop? I was going to save that for a little later, but I assume as the litigation is still going, I don't want to, dip into the secret sauce or anything, but why don't you tell us a little bit about that?
Sure. Well, look, Juul, which is the electronic cigarette that sort of lit the world on fire in 2015. And Juul was very successful in walking through an unregulated space. So combustible cigarettes, heavily regulated, real specific requirements. You can't advertise, you can't market the way you used to market. You have to warn about the dangers of combustible cigarettes. There's age requirements for the sale of combustible cigarettes. And these two guys, Stanford graduates, James Monsees and Adam Bowen, who started Juul, realized that they were in uncharted territory. They were able to have an electronic cigarette that looked just like a USB device. So it's a very kind of cool, slick, innocuous device, and carried nicotine. And nicotine is more addictive than alcohol. It's more addictive than barbiturates.
Wow.
And so what happened was kids who did not realize, I think initially, that the electronic cigarettes that they were using actually contained nicotine, because they had a lot of fun flavors. They like creme brulee and apple pie, ridiculous flavors that were attracting middle school and high school kids to start using it. Didn't even realize that it contained nicotine. And once they started using it, and once that nicotine hits your deep lung, you're hooked and you're in trouble.
And you can get those at the gas station. You can get them, various places.
Convenience stores, gas stations, and of course, online. There's lots of ways to get them. And millions of kids across the country. There had been a declining population of combustible cigarette users coming into the 2000s. Coming into 2010, we were at the low ebb of an arc of nicotine using humans. And all of a sudden, this epidemic of electronic cigarettes that didn't smell like tobacco and were kind of fun and cool to use, and they marketed it as kind of a fun, cool kind of the Marlboro man of the old days is how they packaged it in the new days in a slick social media, online, cool kids approach that hooked millions and millions of, we call them nicotine naive kids who were not onto nicotine beforehand, got hooked on nicotine going forward. And so I saw this happening very early. It was 2019, and began to develop an understanding, and ultimately filed, I think June 2019 was maybe when we filed our very first claim, individual claim, for the damages that a client of ours, he was placed in a medically induced coma. Both of his lungs shut down and nearly died as a result of his use of the Juul product. And that was the first case that we filed.
Yeah, I mean, I remember when I saw those things first coming out, and I think the cartridges had like different colors maybe. And I also, it's funny you bring up creme brulee. I remember thinking, I was like, there's a lot of funky flavors for something of this nature. And goodness gracious, all I have to do for 5 seconds is put my mentality back into where I was in elementary school or high school. You know, you want to be the cool kid with the cool thing that the elders are telling you not to touch. It seems like, yeah, that could lead to some horrible stuff. I hope that client of yours is okay. And of course, I wish you the best on that case. Let's transition to one that I think, Porter Ranch, last I heard, there was a resolution there.
There was. So we were able to resolve all of the Porter Ranch claims. It's a process that's going to start to unfold now. It's a work in progress, which is how to allocate the total settlement as approved is $1.8 billion for about 36,000 folks who were injured as a result of their exposure. The challenge, of course, now is going to be how to figure out a plan of allocation to develop a mechanism to take that $1.8 billion and figure out a reasonable way to allocate it among all the plaintiffs. That's the process happening right now.
Is there a structure for that? Is there, hey, it's usually done this way, but X, Y, and Z?
It's a great question. I would say that there is no formula that you can necessarily follow, because it really has to be based in part on what the injury is and what the understanding mechanism is of the harm that's been caused and the damages that resulted from it. So there might be people saying, hey, I got cancer. I developed cancer as a result of my exposure to the mercaptans in the natural gas. But then you have to develop a mechanism to how are you going to establish that the mercaptans actually caused the cancer you allege occurred. So there needs to be a process you put in place to appropriately evaluate how those claims are going to be determined.
Is it like, I know in class action we use the settlement administrators. Is there a third party that administrates all this, or does it go through the firms?
No, it has got to be an independent third party. And typically what happens, and will happen here, is independent judicial officers, retired judges, will come up with a mechanism to evaluate each of the claims and then develop where each of the claims fall within the spectrum of injury. There's a claims administrator, just like you would in the class action, that deals with the distribution of those funds. But the initial clinical evaluation is going to be done by presentations to the retired judges and or Judge Buckley, who's our sitting judge, on the injuries that you have and how to value them.
Were you, I'm familiar with the PG&E settlement with the fires, I believe, up north. I also know there's some sensitivities there. Were you involved with that?
I was not. I am involved in the Woolsey fire. I don't have a huge number of clients, but I am involved in the Woolsey fire, but I've not done the fire litigation around the state that other firms have.
Are you familiar with the settlement practice where the victims or the plaintiffs, they got a piece of the stock of the company?
No, I recall, if I'm thinking right, that PG&E declared bankruptcy, and they took some of their shares in the bankruptcy, and they may have put that into the settlement fund as a way to fund the resolution for the case, but I don't know enough about really the dynamics of that, how that happened.
I was watching a news story, and look, one thing I've noticed about the news, they don't always get the law correct. That's been my personal experience. But what they were basically saying is the stock is tanked. And so all these people who are supposed to get money aren't getting any money to begin with. Look, I understand that you're involved with fires up north as well. I don't want to get too much into the special sauce, as I call it. But do you have any thoughts or feelings on that?
Well, look, I mean, when you've got a defendant who declares bankruptcy, you've got to figure out what's the most effective way to provide recovery for your client. Look, the worst case scenario, this is happening right now, and this is outrageous. This involves Johnson & Johnson and ovarian cancer and the use of baby powder. So my firm was privileged enough with a couple of other great firms some years ago to try a case against Johnson & Johnson for Mrs. Echeverria. Mrs. Echeverria had used baby powder and developed ovarian cancer, and a jury in LA awarded her in excess of $400 million for her ovarian cancer. Several days after the award was entered, Mrs. Echeverria died as a result of her injuries. What happened about a month ago was Johnson & Johnson created a new company. They split out the talcum litigation from the Johnson & Johnson division that oversaw baby powder. And they created a new company in Texas. And the only thing in that company's business was the talc litigation. So they created an entity. There's two states, Texas and Delaware, I believe, are the only states in the union that allow you to do this. So they severed out their talc liability. They put it in a separate corporation, and then they put $2 billion from Johnson & Johnson Consumer Products, I think was the division that they pulled it out of, took $2 billion, put that in the talc corporation, and then bankrupted it. So every single talc case across the United States, and there's tens of thousands of them, are stopped or frozen or stayed. They're done. If this works, it's called the Texas TwoStep. If this works, Johnson & Johnson will have effectively peeled out their liability on talc, funded it with $2 billion, and they walk away from everything. They filed bankruptcy in North Carolina. They created the corporation in Texas. They filed bankruptcy in North Carolina. About 2 weeks ago, the North Carolina judge heard the preliminary bankruptcy petition and said, well, why are we in North Carolina? This ought to be in New Jersey, where y'all are based, where the MDL is happening for the talc litigation. My firm is liaison counsel in the talc litigation here in California. Mark Robinson is lead. We're liaison counsel, but our cases are now stayed. There's an MDL, a multi-district litigation case in New Jersey, and the bankruptcy judge in North Carolina is sending those cases to New Jersey. But here's the deal: if this is successful, it's a model that corporations can use to create devastating harm to individuals.
Yeah.
Roundup against Monsanto and Bayer. They could peel off their Roundup litigation, put it in a separately held company, fund it with whatever dollars they want to fund it with, and then walk away from any further liability for that bad act. That's what they could potentially do. And it's terrible, but it's happening right now.
It sounds like in California, that would be, alter ego, shell corporation, single entity, that kind of stuff. But I guess not in Texas.
Fraud
Yeah.
in California. Right.
Yeah, but not in Texas.
Not in Texas, not in Delaware. Correct.
It's people. Sometimes people say to me, "Oh, Daniel, too many trial attorneys, blah, blah, blah." Look at the resources these billion-dollar corporations have. And do you guys think that they're using them to enrich anyone other than their stockholders and board? And it's so wild to me, the as time goes on more and more, I realize the outlandish advantage some of these corporations have. And it's not just through watching the news and stuff, it's through my own practice. A company that's playing defense, they have access to all the skeletons. They're not just going to turn them over to you in discovery. They're going to make your life difficult before they produce that information to you. And imagine you're a corporation with billions of dollars of resources. I mean, how much time and effort do you think, Paul, they put into coming up with that Texas two-step?
A lot of times in my practice, I'll stop and I'll think, God, I'm like living in a movie. This feels like a movie. That I have that thought a lot of times as I'm involved in this litigation. We're right now in a trial in San Bernardino, and on August 15th, 5 defense lawyers, not all the lawyers in this case, but 5 of the defense lawyers tested positive for COVID. I think they've got 20 lawyers on the other side of this one case, at least 20 visible lawyers. I have no idea how many more are back in hotel rooms or offices. It's crazy the amount of resources that these corporations are able to bring to bear on this process.
Yeah, and I always take a stance that aspect of society. I mean, when you have those resources, when you have the amount of money, when you have 20 attorneys there, 5 of them are sick at home, another 100 at the firm, the amount of resources these corporations have to do things with the marketing. I remember a good example, I think, is the McDonald's hot coffee case, which everyone knows about. I just remember after the case came out, and I'm not going to go over what actually happened to the poor woman. Those of you who are interested, Google what her injuries look like, and then come back to me and tell me it was just about hot coffee.
After Stella Liebeck, who was the plaintiff in that case, Stella only wanted her medical bills covered. Mm-hmm. Her original request is just pay my medical bills.
Yeah.
So it all unfolded after they refused her really reasonable request to just pay her medical bills back.
Mm-hmm.
But that's right.
But then all the news networks, especially the financially oriented ones, McDonald's is sued because their coffee's too hot. No, it's not that simple. But then tort reform and this and that. And look, I'm not saying there isn't aspects of any business, any practice, medical, legal, engineers, architects. There's certainly going to be unsavory aspects of any practice out there. But to kill the worthwhile stuff, the kind of stuff that you're doing in order to stop the unsavory stuff, is a real ethical qualm that huge red flags go up in my head. So, look, I'm a plaintiff's attorney. We all know what side of that argument I'm going to fall on. But let me switch this conversation. Let me say, I have so much, honestly, Paul, I have so much to speak with you about, and in our time, I've already taken up so much of your time. Let's go to this question. I always love asking this question. You are, by any way of looking at this, let me pull up some of these photos of you, Paul, doing the things that you're doing. I think by any stretch of the imagination, you are what we would call a successful attorney. Do you see the images of yourself up on the screen? Did I do this correctly?
I see the president. I see my daughter, Lauren, when she was younger in that picture. We were all younger in that picture.
Okay. So we have that one.
Laura's a lawyer now. Lauren went to UCLA Law School and is now doing immigration work at a pro bono firm here in LA. So that's good on her. Here's you, and I wish we had the full photo here. For those of you who aren't, this is a crop photo. Paul is in his private jet. He's wearing a very nice shirt. He's got the suspenders. He's got the fashion forward glasses, and the guy's managed to maintain a full head of hair throughout that whole process. Kind of what I'm getting at here, Paul. Here he is, President Obama. Here we go again. I think that's Gray Davis over there. We have President Clinton. Actually, go back. That was Gray Davis and Brown and Governor Brown.
Okay. Yeah, there they are.
Actually, look at this picture. This is Lee Baca, who's a sad story. He was the sheriff of Los Angeles. Jerry Brown and Governor Davis and his wife Sharon. That's and my wife Dana and me. That I remember that day very, very vividly. Sorry.
You seem to have had a rather, let's just say, charmed life? I mean, I'm not saying you don't deserve it. You obviously put in the work. That's not what I'm saying. But how did you pull this off? How did you get to where you are? And what's your advice for people in their mid 30s, lawyers?
I'm going to say on the one hand, humility. I mean, I'm embarrassed in some ways by this. And I think, being humble is important. I usually, when I'm doing a presentation, I always say, don't spend time talking about me. I'm happy to share my thoughts with you, but if you want to know about me, go online. It's all there. You can read about it. I think having humility is really important. And I think it plays off with a jury. I just think if you're arrogant, if you're self-righteous, I believe, as my parents taught me my whole life, giving back is the lifeblood of the community. And so if I really have one thing that really was the hallmark of my career was giving back, and I continue to give back. So I really think it's really important we get involved, that you don't live selflessly, just trying to build your own life up, but you ask how you can help others, how you can make a difference in the lives of people around you. And it's always put it out there, and good things are going to come back to you. I almost never do something merely for the sake of getting something back in return. I give up a lot of time for public service. I've done a lot of work on behalf of the courts and the state of California, and I do it because I love it. I do it because it's important work, not because I'm going to build a career as a result of it. So I would say that do it because you genuinely want to, not because you have to. But in your heart, if you feel like you can contribute back, good things will happen. And that's really my best advice is don't be so focused on your practice and kind of building up something just because you want to build it, but give back to others, to the community, and good things will come back to you in return. I really believe that.
Very, very impressive, Paul. You honor me by allowing me to see. I have such a great job in these podcasts. I get to speak with people, titans of the industry, and just ask you the questions that come across my mind. And I'm so curious, and I have so many more questions. Paul, you and I could do a 3-hour podcast easily. And the time flew. It's been an hour. We would love to have you back on. I don't want to take any more of your time, but I would love to have you back on. I'd also love to talk to you off air briefly, if we can, about the proposals of the state bar. But it has been such a delight. And just from the top down, those of us watching at home, first takeaway, look at how Paul speaks. Look at the way he presents himself, the energy, the passion, the excitement. Paul, you could talk about a hamburger and make it extremely interesting. That much is pretty obvious to me, just speaking to you for about an hour.
What I like to say is this, I work 24/7. I do. I'm always engaged, but I always say I've not worked a single day in 36 years. I've never, and when it becomes work, I'm going to stop doing it. I never think of this as work. I always think of it as just sort of a life. This is my lifestyle, is doing this. It's not work. I've been with my wife for 33 years. And Dana and I have a fantastic relationship because Dana lets me do this stuff. No matter when we were on the Inca Trail, I had with me a satellite phone. So if a client needed to reach me, I'd be on the Inca Trail, but the client could still reach me no matter where I go. I tell my clients, I travel a ton. Dana and I are going to Antarctica on December the 11th. That's my last continent on Earth. I tell my clients, I am out of town a lot. I used to be, but you can always reach me if you need me. And this is the hallmark of a practice. I really believe that we as lawyers need to be responsive to our clients first and foremost. So I always tell my client, if you call me, you don't have to call again. I'm open 24 hours a day, 7 days a week. If I don't call you back, it's because I did not want to talk to you. Not that I didn't get the message. I always get the message. So that's just another axiom of mine.
I mean, so many lawyers, they get a little bitter about the job. I can understand maybe it's a hard job. Maybe they didn't make the money they expected. Maybe they didn't accomplish the goals they wanted. It is nice to hear. And I always tell younger attorneys always say this to me, Paul, and I bet you, they say, oh, all the older attorneys tell me, or people planning on going to law school tell me, oh, all the attorneys tell me don't take the job. Really? I think besides being a fulfilling job, you have a lot of power, the ability to file a lawsuit. Look what you're doing with Jewel, Porter Ranch, so on and so forth. So it's refreshing to hear. There's another person who's planning on going to law school, and she told me that everyone told her not to go. I'm going to send this podcast to her, and I'm going to see what she thinks afterwards.
Have her call me. I mean, I literally would never mind. You can have her call me and talk to me. I tell people, don't go to law school because you think it's what you should do, or it's going to buy time. If you love what you do, if you think this could be a rewarding career, embrace it. You'll never regret it.
Lots of words of wisdom, passion, having an affection for the job that you're doing, and you'll never work again. Being available to his clients. Obviously, the man loves what he's doing. Paul, you have done us all a tremendous service by giving us an hour of your time. I am indebted to you. I sincerely appreciate it. I'll give you the last word, then I'll stop the recording.
I've been schmoozing with Forouzan. I'm done.
All right, guys. See you on the next one.